Hello, I trust that everyone is well. I welcome you to Kabale University Faculty of Law. My name is Dr. Charlotte Kabaseke, a lecturer and currently the acting dean of the Faculty of Law of Kabale University. I will be taking you through Introduction to Law, a course whose major aim is to introduce you to the basic aspects of law before you interact with other areas of law or courses which you will be studying at this faculty. In this course, we are going to look at the definition of law. We shall define law. We shall highlight the characteristics of law from the definition that we shall have arrived at. We shall also talk about the purpose of law, the classification of law, different categories of law. We shall then look at the sources of law, which is basically aimed to introduce you to where Uganda derives its law from, or where did we get our law from as Uganda. I'll then introduce you to the lawmaking process on how laws are made in Uganda. And as you might be aware, we have three arms of government: the executive, the legislature, and the judiciary. And although it is the role of the legislature to make law in Uganda, it is the role of the judiciary to implement that law. So it will also be important for you to be taken through the court process or the court system in Uganda so that you get a glimpse of how judges in the courts of law really arrive at decision making and interpreting the law in order to arrive at the right decisions or fair decisions while adjudicating cases. And because as part of your duties and at the law school, and also because most of your time will be revolved around reading cases as part of the law in Uganda, you'll be introduced to writing a case note or reading judgments, court judgments, and interpreting the same. And you'll basically be taken through the techniques of writing a judgment, because as you know, some of you will be judicial officers in future. And then because you're going to take your first exams in law school, we shall have a discussion later and we'll be given tips and guidance on how to write and pass the law exam. So in summary, that's what the content of Introduction to Law is. Now, when it comes to the definition of law, which is basically going to be our first topic, it is important for you to note that there is no general definition of law. Law varies according to society, according to community, according to states, according to different regions of the world. So you'll also realize that in the definition of law, some scholars have attempted to define law. Some very important figures really in law who have gone before us and have attempted to define law. They've also defined it differently. And these scholars have these scholars subscribe to different schools of law or schools of thought. And we'll begin with Thomas Aquinas, who is the propounder of the natural school of law, together with his other colleagues under the same theory, defined law as being natural and inborn. They argue that someone knows the right thing or the wrong thing at birth, and that law is God-given, and that when someone is born, they are born with a conscience, and they know and should know the difference between right and wrong. So they argue that law doesn't necessarily have to be written because an individual, that law is written within an individual, that an individual should be able to differentiate what is right and what is wrong. And according to them, law is the natural order of things, that the right and wrong are within a person, they are born with that person, and according to them, what is right and what is wrong according to nature is what is law according to them. We then look at John Austin, Jeremy Bentham, Thomas Hobbes, among others, who are the proponents of the positivist school of law. And the positivist school of law, or the positivists, really argue that law are those commands that are given by a sovereign, that whoever is in power and whatever they dictate is what should be law. Whether the people who are being governed agree with it or not, that is what becomes law. There's no room for negotiation. So according to them, whoever is in power, whoever the command is, whoever the sovereign is, will dictate or will say what the law is, and that's what will become law at that time. The pure theory of law, as advanced by Hans Kelsen, on the other hand, argues that law cannot be law except if there's a constitution in place. The positivists introduced the concept of the grand norm and argue that there may be so many other guidelines and laws maybe, but there should be a constitution which sets the standard of behavior for everyone in the community, which sets the standard of conduct for everyone in the community, and therefore they believe that there may be so many other laws, but they are not really law unless a constitution is in place and has dictated the order of things. Of course, you realize that the system in Uganda really is biased towards the Hans Kelsen pure theory of law, as is commonly known, because we have a constitution in place. There are many other scholars, including the Marxists, as advanced by Karl Marx, who basically argue that good law or law is really based on what favors the economy, what supports the economy at that time. And they argue that in future, communism will take over most of the countries and governance, and of course that at the end of the day, what the sovereign guides in respect to the same is what will be known as law. And then of course we have the realist movement. The realists believe that law is really the reality that is on ground, that whatever is reality, whatever is happening on ground in a particular community should inform what the law is. That law shouldn't be based on ideas of probably what might happen in the future or what is anticipated, but rather what is real on ground, so that the reality on ground, the circumstances on ground, should really inform and dictate what the law is. Then we have the historical school of thought as advanced by von Savigny. We have the sociological school of thought as advanced by Montesquieu and Roscoe Pound, among others. And these two schools are similar, with the sociological school basically advancing the fact that we cannot define law if it is not in reference to our customs, that our customs inform law, that all of us belong to communities, and those communities have customs and beliefs which shape the standard of behavior in those different communities, and that we can't say that we have law if it does not speak to the customs of each community. And then the historical school similarly advances culture and say that before we can say that we have law, it should speak to the culture of the specific community to which it applies. So we'll quickly then go to the next step, which is what then is law. Having seen that there's really different definitions of law depending on how each person defining views the circumstances, we shall come up with a working definition of law. What we see is that at the end of the day, law is a set of rules and regulations which govern a particular community, and breach of which will attract a sanction. And from this definition, we can see that some of the characteristics of law include that there is a set of rules, that it is applicable to a specific community, because there's no general law that governs the whole world. It should be specific to a community, or maybe a country and a state, or a specific group of people. and it guides human conduct. Law does not guide objects. It is specific to human conduct, and it is applicable to all persons. And as you realize later, for example, the Constitution of the Republic of Uganda in Article 21 provides that all people are equal before and under the law. So law, to be fair and just, has to be applicable to all persons. And definitely, if anyone breaches that law, they will be punished, or it will attract a sanction. So what then is the purpose of law? The purpose of law is basically it's used as a tool for social control, and in most cases to prevent errant behavior or to control errant behavior. It guarantees civil rights and liberties. Every individual has rights, and in Uganda they are guaranteed under Chapter 4 of the Constitution of the Republic of Uganda. So law is in place to ensure that citizens enjoy those rights. It ensures public safety. For example, we have traffic laws like the Traffic and Road Safety Act. Law ensures public health, among others. We have the Public Health Act. The law helps protect people's property. The law protects the environment. The law is used as a tool for fiscal policy and regulates the economy. That's why we have tax laws. Law fosters cooperation and good neighborliness between individuals, because you have to be at peace, to live at peace with your neighbors. You can't, violate your neighbors' rights and walk away scot-free. So in a way, this forces people to live in harmony with each other. And of course, the law also helps governments or countries or states to be accountable to their citizens, in the sense that states are under obligation, for example, to protect their citizens and their property. So when we look at branches of law like criminal law, administrative law, constitutional law, among others, it is just an indicator that law is in place to also hold governments accountable to their citizens. We shall now look at the different classifications of law. We won't dwell much on this, but just highlights and pointers. Law is classified, like I already told you in the introduction, and among the classifications there is national law as against international law. National law, going by its name, is sometimes known as domestic law or municipal law, and it is the law that governs a specific country or state within its particular borders, and usually this is measured against international law, which is basically law that regulates relations between two or more states. So whereas national law or domestic law or municipal law applies to a specific state, international law applies beyond borders. As long as there's a relationship between two or more states, the law that will govern them is international law. For example, the relations between Kenya and Uganda, or between the East African countries, or even between Uganda and other countries, is international law. We then have public and private law. And all national law, so to say, is either public law or private law. Public law majorly bridges the relationship or seals the relationship between a country and its citizens. Public law, again, holds governments accountable to their citizens, because a government, for example, has the duty to protect a person and their property. So if my property is stolen, the law that will help me recover my property or get compensated is criminal law. And it is the government that has the responsibility of prosecuting the person that has stolen my property. So therefore, in doing that and establishing that relationship and ensuring that a country indeed meets its obligations towards its individuals, we use public law. And it is measured against private law, which is majorly aimed to improve a relationship between citizens. Again, to ensure that citizens are living in harmony and to help persons basically live together in a community. That is private law. And under private law, we have branches of law again, like contract law, family law, land law, among others. We then have criminal law and civil law. Criminal law is that branch of law that is majorly aimed to punish offenders, whereas civil law is that branch of law that is majorly aimed to, again, promote relationship between persons or citizens, but also to ensure that citizens who have suffered civil wrong or who have suffered wrongs are compensated for the wrong suffered to them. And as we go along, you will appreciate these differences better. But civil law, for now, fosters relationship between persons. So to say, I have my land or property, don't trespass on it. If we've entered into a contract or an agreement, all of us are under obligation to meet our part of the obligation. If we are a married couple, for example, all of us have rights and obligations towards each other. So civil law helps take care of that. Then we have military law as against civilian law. Military law basically applies to members of the armed forces, people serving in the armed forces. And for Uganda, I'll give an example of the members of the Uganda People's Defense Forces, concerning their behavior, concerning the procedure taken in case they commit a crime. You know that they are not tried in civil courts, for example, but they are military courts to handle their affairs. And then, of course, civilian law is law that applies to civilians, persons like myself and maybe most of us here in this classroom. And of course, civilians ordinarily shouldn't be tried in military courts, of course, with a few exceptions. Then we'll go to substantive law and procedural law. Substantive law being the actual written law as is written in the books. For example, the Constitution of the Republic of Uganda, the Penal Code Act, the Children Act, the Evidence Act, and all as it is written on the books. So substantive law is majorly law on the books, whereas procedural law are the steps that a person or an individual is required to take in order to have their rights, maybe, and liberties as enforced in substantive law realized. So if you want to realize all your rights and obligations under substantive law, you will need to go through certain steps which are governed by procedural. And finally, we have written law as against unwritten law. And again, I'll say that written law is law that is written, that you can read for yourself from the law statutes, whereas unwritten law is law that is applicable but is not written. For example, customary law. Customary law, which is law that arises out of our customs, is also binding on the peoples of Uganda to an extent, but it is not written. And of course, other principles like principles of justice, fairness, and equity, which are also applicable but are not written. As I conclude, I thought I should introduce you to the sources of law in Uganda. Where does Uganda derive its law from? The first place to go to is always the Constitution of Uganda, like I mentioned under the Hans Kelsen pure theory of law. He argues that without a constitution, there is no law to refer to. So all laws in Uganda must be in line with the Constitution. It sets the pace for the enactment of other laws, and it sets the standard. What this means is that whatever other law is made or whatever other law is applicable, whether written or unwritten, it should be in line with the Constitution. And this is provided for in Article 2 of the Constitution of the Republic of Uganda, which provides that the Constitution is the supreme law of Uganda, and any other law or custom, I would say, or even practice that is not in line with the Constitution is null and void. Always keep that in mind. Then we have other acts of parliament, statute, or legislation, or basically written law, which is other written law other than the Constitution. So, and I've written for you this law sort of in order of which it follows each other, like sort of in a hierarchy, meaning that even if you're putting across any argument or any legal argument, you must cite the Constitution of the Republic of Uganda. If you don't find an appropriate legal provision there, then you will switch to the Acts of Parliament, statutes, or legislation. And if you don't find any there, then you can go to subsidiary legislation. So what is the difference between Acts of Parliament and subsidiary legislation or delegated legislation or secondary legislation, that is sometimes known? The difference is that you realize that Article 79 of the Constitution of the Republic of Uganda places the duty upon Parliament, which is our legislative body, to enact laws. But because of many reasons, including the fact that Parliament is busy and they have a lot of other business to attend to, they can delegate that authority. Still under Article 79, Clause 2, they can delegate that authority to any other bodies. It could be the minister, it could be the Chief Justice, as they may deem fit, so that this law is enacted. So the concept of Parliament delegating its law making authority to another body is where the name delegated legislation is made. And delegated legislation is usually found in rules, regulations, for example, employment regulations, land regulations, PPDA regulations, among others. Then we have common law and the doctrine of equity. Common law is basically law that we inherited from England. Law that was applicable in England, details of which we shall go through later. And at colonization, we inherited common law. The name common law is basically derived from the fact that previously in England, when the king or the king's judges, who are not really formal judges, but people selected by him to adjudicate cases, when they would go around England adjudicating, in the communities of England back then to adjudicate cases, they would apply custom that was common to the people of England. So because they applied common customs in adjudication of cases in communities, that's where the name common law was derived from. And when we talk about doctrines of equity were basically introduced to easen up the tight loops of common law. Common law was sometimes so tight, so they thought introduction of the doctrine of equity, which is basically fairness, would come in to make common law a bit lighter. And these doctrines were basically based on fairness, depending on the circumstances of each case. So where common law was so hard, where sometimes even the customs would occasion an injustice, instead equity or fairness principles would be brought in order to conclude a case. And then, of course, one of our sources of law is case law or judicial decisions. You know that in Uganda, just like many other places in the world, we apply case law or judicial decisions, or even judges make law. And actually, hence the doctrine of precedent. You realize that that doctrine requires that courts of law will refer to the decisions of judges before them, especially if the judgments are from higher courts, in order to inform the decisions that are going to be made in adjudication of the cases before them. Then we have customary law. I've already mentioned that we have some law that is derived from our different customs across the country, depending on which community. Again, customary law is not written, but is known by the people to whom a particular custom applies. So the application of customary law varies from community to community, and there are different characteristics and guidelines and confines within which customary law is applicable, and we shall look at that later when we are looking at the sources of law in detail. Finally, we have international law. Like I've already mentioned, yes, we have our domestic law, but we also have international obligations, whereby Uganda is party to different treaties and conventions across the globe. and once ratified and domesticated, Uganda has an obligation to apply those international law principles. The sources of law in Uganda are provided for under sections 14 and 15 of the Judicature Act, Cap 3, which I invite you to look at. But for this module, we are going to close it here. This was just an introductory lecture, and we shall look at most of these other concepts in detail. Thank you so much for attending this class. It's been a pleasure to introduce you to the law. If there are any questions, thoughts, suggestions, or comments, I welcome them. Thank you so much.